we've been discussing about mostly in the U.S. Let's bring it into Canada. This one is to Elizabeth. So do you think that the legal environment here in Canada would allow for a Madison Moment to happen here? So is it exportable, do you think?
Well, as the token lawyer on the panel, I'm going to ask us to step down from this lofty plane for a few minutes and talk about law. Because the tool that legislatures are using here to attack public sector collective bargaining rights and terms and conditions of employment is law. They're stripping contracts, so they're stripping away substantive rights, and they're also stripping away procedural rights, the right to collective bargaining and to resolve bargaining disputes in particular kinds of ways. So the obvious question for us here in Canada is, are there legal constraints in Canada that would operate in ways that would be more effective, perhaps, than what's going on south of the border in restraining governments from taking those kinds of actions. And I think we need to get a bit of historical perspective here too, because one of the things I did in preparing for tonight was go back and read an article I'd written in 1978, and that I'm sure some of you were not even born in 1978, but in the grand scheme of things, that's not that long ago. And the topic of the article was public sector collective bargaining rights in Nova Scotia. And in 1978, public servants in Nova Scotia did not have collective bargaining rights. Collective bargaining rights are, in the public sector, are much more recent than they are in the private sector. There have almost always been limitations on collective bargaining rights in the public sector. For public servants, really it wasn't until the 1970s that they became widespread in Canada. For public employees who weren't public servants, there were often constraints on what you could bargain about, constraints on the scope of bargaining, all sorts of things that were by statute taken off the bargaining table. And there still are. That's not unusual in Canada. But there have, of course, been massive changes in that area since the 1970s. Much broader scope bargaining, and expectation that public sector employees will bargain in the same way as private sector employees. And those changes took place through worker mobilization and through political action. So whatever might be happening now, it's probably not a whole lot worse than what the situation was 30 years ago, perhaps, and those kinds of things can be changed. Movement can happen in law through political action. I'm sure that's not news to most of you. But there is something we have now which we didn't have in 1978, and that's the Canadian Charter of Rights and Freedoms and constitutional guarantees of freedom of association. And we have had those since the early 1980s. It took the courts much longer than that to figure out that those constitutional protections for freedom of association actually protected collective bargaining. But the major breakthrough case was a case called BC Health Services, which I'm sure many of you have heard about, a decision of the Supreme Court of Canada in 2007. And in 2007, the Supreme Court of Canada dealt with the constitutionality of some government action in British Columbia in which the government stripped collectively bargained contractual rights from healthcare workers and changed the rules to say that those particular topics could not come back to the bargaining table. So it took away substantive rights and it took away procedural rights. And our Supreme Court said that's unconstitutional in Canada. That violates freedom of association. Governments cannot do that. So, how important is that really? How important is it that the Supreme Court of Canada says that? Does constitutional law really matter in this area? Well, think Bill 16. Think last summer in Ontario, where the Ontario government was trying to put in place wage controls for a broad spectrum of public employees, not just public servants, but the broader public sector as well. And we've had, those of you like myself with long memories will remember that wage controls are not unheard of in Canada. We've had many rounds of wage controls. Governments did wage controls in the 1970s, they did wage controls in the 1980s, they did wage controls in the 1990s. So what did they do in Ontario after the decision in BC Health Services? They imposed wage controls on non-unionized employees, but they did not impose wage controls on unionized employees. Why did they make that distinction? I can't say I know for sure, but absolutely everybody I have talked to, inside government, outside government, people who sat at those union consultation tables last summer with the government, they all say the government was afraid to legislate wage controls for unionized workers because of BC Health Services. They thought that if they did it, it would be unconstitutional. So they didn't do it. And the arbitrated settlements for unionized workers in the public sector did not comply with governmental guidelines and governmental hopes that everybody would kind of get with the program here and accept wage controls. It didn't happen. Arbitrated settlements were in the neighborhood of 2% annually. Some of them were higher than that. And the net result was some brand new union organizing, because it was nakedly obvious to public servants that if they were not unionized, they were not going to get a raise, and if they were unionized, they probably would. And so there were some real breakthroughs here in for example, hospitals. The certain units of hospital employees, nurses, in some hospitals that had been holdouts for years, had not been interested in organizing, all of a sudden were interested in organizing. Made applications for certification for the Labor Relations Court. So constitutional law really can make a difference in this area. Now, I'm probably past my 5 minutes here, so I'm just going to take 2 more minutes to talk about the Supreme Court of Canada's most recent constitutional law case, because of course one of the questions you may be asking if you're a labor constitutional law junkie is whether all of that changed when the government, not very long ago, a couple months ago, ruled that the Ontario government's latest effort at labor legislation for agricultural workers was constitutional, notwithstanding that it had absolutely no features that any of us would recognize as a collective bargaining statute. And that is widely regarded as a huge step backwards from BC Health Services, and it is indeed a huge step backwards from BC Health Services. But it doesn't touch one whit the court's holdings in BC Health Services. In fact, the court reaffirmed BC Health Services, made a distinction between positive governmental action. In other words, do governments have to pass good collective bargaining legislation for employees who don't already have it? Answer, no. But the court said, but that's a very different thing from taking rights, substantive and procedural rights, away from people who already had them, from stripping contracts and barring collective bargaining on those kinds of issues. And the same two judges who wrote BC Health Services wrote the majority decision in Fraser and repeated everything they had said in BC Health Services, and repeated it even more clearly than they had stated it in BC Health Services. So I don't think there's a whole lot of comfort in Fraser for governments who may want to strip rights, contract rights and collective bargaining rights from public employees. So there may be some good news for Canadian public employees that we may have some solid anchors for rights that are not available to our brothers and sisters of the board.
Thank you. Does anyone want to add anything to that?
Well, actually, I remember when the BC healthcare decision came out, I got it right away. I read it quickly, and I wrote a quick article and sent it to all my American friends and said, hey, eat your heart out. And just as I hit send, I realized, wait a minute, I live in the U.S. You know, and I was very disappointed. But there are some really important things, though, that pull in the other direction. Private sector employees in Canada, unlike in the U.S., private sector employees in the U.S. are covered by one national labor law, the National Labor Relations Act. In Canada, the vast majority of private sector workers are covered by provincial law. That means that a provincial government can bring in some pretty reactionary things. And while, yes, you know, collective bargaining is a constitutional right of Canadians, who said the RAND formula fits in there? So why not, at a provincial level, bring in all sorts of, because the real killer in the U.S. hasn't, the few states that have basically tried to abolish collective bargaining totally, those are the ones that have had these great uprisings and that I think will, in fact, be turned back. The really sneaky, dirty ones are the ones that kneecap labor by going after things like our ability to collect dues from members, by saying, hey, you know, we think it doesn't make sense that employers should be collecting dues for unions, so they abolish dues checkoff, and in fact go one step further, make it illegal, so that then a union is not even able to negotiate with an employer to have dues checkoff. Freedom of association includes the freedom not to associate, and that leads to the so-called right to work for less states. So that there's all sorts of things you could do to tie the hands of unions, and in fact that's where things like the ALEC and the State Policy Network have been working for many, many years on thinking about what sort of small pieces of legislation would so handicap unions as to make things very difficult. An example is when Indiana went right to work, which basically just said, and this is where the Canadian system also has the same pernicious aspect of the Wagner Act, exclusive representation. A union is required to represent all of the members in a bargaining unit, whether they choose to be members of the union or not. Historically in Canada, through a decision called the RAND formula, in the vast majority of public and private sector jurisdictions, it's understood that because the union will be representing, is obliged to represent them, then all of the folks covered should in fact pay for that service through union dues. In the US, that's not well understood and in fact is constantly undermined. But you could see that something like that would very quickly undermine the financial base of the Canadian labor movement. After all, who is Justice Rand? Who remembers 1945? And one of the problems I think the Americans have had is it's very difficult to mount a campaign, defend the Rand formula. It's not what you want to put on a bumper sticker. And it's difficult to understand, and it sounds so obscure. So I think there's one of the key lessons of the U.S. is that this happened, a lot of attention was at the federal level, and this happened at the level of the states. And in Canada, the provinces have so much more power over labor than an American state. An American state can only mess with public sector labor law, and in one instance, can deal with one aspect of private sector labor law, but Canadian provinces can and have write most of the labor law that applies to both public as well as private sector workers.
I just wanted to say something about the RAND formula. There have been a series of constitutional challenges. There are downsides to the charter as well as upsides to the charter, of course. And one of the downsides was a series of constitutional challenges to union security, various union security provisions protected by statute and collectively bargained. But in all cases, our court has gone in a different direction than the U.S. Supreme Court, and has said that those kinds of provisions in collective agreements and protected by statute don't violate freedom of association and freedom of expression, which is, of course, not to say that they're constitutionally required, but at least unconstitutional.